Judge Brislin wanted to participate, but she wouldn't be able to. So she asked us to record this session so she could hear from all of us that way. Should I start introducing Ms. Sheila Donovan?
Yeah, let's go ahead and get started.
All right. Sheila Donovan grew up in Massachusetts and attended Smith College there, majoring in psychology. After graduating, she worked in the mental health profession for more than 10 years. Prior to attending law school at the University of Kentucky and entering private practice, she spent many years as the senior crisis line counselor for comprehensive care for Central Kentucky. She concentrates her practice in all aspects of family law. She's a certified parenting coordinator. She's also a certified mediator and GAL. She is a member of the Association of Family and Conciliation Courts. She lectures regularly on legal issues. She was formerly the chair of the family law section of the Kentucky Bar Association and the Fayette County Bar Association. So she serves on the board for Micah Legal as well. She also serves as the alumni representative and president of the local Smith College Club and volunteers as a tutor at the Carnegie Center. I will also introduce Judge Stein. She will be also leading this conversation with us. Judge Kathy Stein was a family court judge for the Fayette County Family Court of the 22nd Judicial Circuit, which serves Fayette County of Kentucky. She was appointed to the court by Governor Steve Beshear on October 14th, 2013, to fill the vacancy created by the retirement of Judge Joanne Wise. Stein was sworn in on October 21st of that year and was elected to a full 8-year term in 2014. Her current term expires on January 1st, 2023. She retired on January 31st, 2022. Stein is also a former Democratic member of the Kentucky State Senate, representing District 13 from 2009 to October 14, 2013. All right, Sheila, do you want to take it away?
Sure. So one other piece of news for most of you know that this is probably my last family court lunch as an attorney, because starting next Friday, I'm just going to do parenting coordination, and it will be Donovan Parenting Coordination LLC. And I'm enjoying myself immensely with working full time and starting a new business and wrapping up my old business. And I had cataract surgery in December, so it's all going really well. I can't wait until March. That's all I'm going to say. I can't wait until March. So I made a bunch of notes when I was asked to kind of start talking about this, because I was like, what statute? So immediately went and kind of looked that up, and I've just kind of made a stream of consciousness, things that have occurred to me since I was brought into the loop on this. So can't see anything with the glasses anymore. So this, as far as I can tell, this statute has not made it out of committee, right? I'm not seeing that. Okay. I just didn't know if somebody had seen something else. So it says, notwithstanding blah, 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 no person, entity, corporation, company, organization, or government agency, public or private, shall require or coerce in any manner any child to receive a vaccination for COVID-19 or any mutated strain of the COVID-19 virus other than the child's parents, de facto or legal custodians or guardians. If one parent objects, the vaccine shall not be administered to the child, and no court shall order the vaccine to be administered to the child. Also can't do a bunch of other things like require face coverings, COVID testing, et cetera, et cetera, et cetera, et cetera. So I kind of backed up and started thinking about this. So a few months ago, we had the Birch versus Lipscomb case that talked about handling medical issues. And it was talking about vaccines, not COVID, because I believe that conversation started pre-COVID. But it kind of laid out a framework for how the courts would handle medical emergencies or issues that arose when parents could not agree. And kind of the big takeaway I would say from this was that if they cannot agree, what will end up happening is that the court, it says the court will intervene. And they kind of even backed up a little bit there and talked a little bit about Troxel versus Granville, which was in the grandparent context, to kind of lay that framework and say, okay, this isn't the first time we've had this conversation. This isn't the first time we've talked about this. Here's how we've handled grandparent visitation. Here's the very specific protocol that we need to follow. And then they start talking about it in this context. And, you know, they talk about the constitutionally protected rights of parents to raise their children free of undue government interference. But what happens when there's an impasse? And they say that our jurisprudence addresses that. A family court properly exercising its jurisdiction has the inherent ability to break the tie when joint custodians cannot agree. Once courts are involved, equal decision-making power is not required for joint custody, and parties or trial courts are free to vest greater authority in one parent, even under a joint custody arrangement. In essence, what they're saying is, if the parents are, in essence, abdicating their role and saying, we're stuck, and the judge comes in, the judge in the Troxel Granville type of situation, and then in the medical decisions, that's what it seemed that Birch and Lipscomb were saying. And then they even reference in Birch and Lipscomb to this other case, the Young versus Holmes, which was a case in Louisville where there was an argument / discussion between the parents about where this little child was going to go to school. And dad wanted the child to go to Catholic school. Mom wanted the child to go to public school. The court said, again, same kind of thought process. If they can't agree on a major issue concerning the child's upbringing, the trial court, with its continuing jurisdiction over custody, must conduct a hearing to evaluate the circumstances and resolve the issue according to the child's best interest. So we were kind of plodding along, it seems to me, filling in the gaps and kind of giving guidance to us as attorneys in terms of how do we handle when they get stuck? What do we do when they can't figure out what's going to happen? From a parenting coordination perspective, I kind of welcomed this because I'm neutral. But if I can say to them, well, you know, if you go to court, here's what this case says. In a very neutral way, I can present that and say, looks to me like if you end up in front of the judge is going to decide. How do you feel about the judge making decisions about your children and you giving that decision-making authority to the stranger down at the courthouse, so to speak? And so, one of the things I wanted to talk about is how is this going to work? Because this statute is rather clear that the way I read it, that the judge even doesn't have any part to play in this conversation. And could be just one parent coming in and just saying no. And that's the end of the conversation. At least that's the way I'm reading it. So I'm going to welcome the conversation about that. But there's another thing that I thought about. This goes back to my days working on the crisis line, is there's a statute that gives some limited ability to teenagers to seek medical advice without permission from their parents. And if you look at KRS 214-185, diagnosis and treatment of disease, addictions, or other conditions of a minor. And this came up because I used to have teenagers would call the crisis line. They would be depressed or, broke up with their boyfriend or things like that. And they would want to be able to talk to someone. Well, if you look at that statute, there's a distinction between medical and kind of more mental health pieces, but there's some stuff out there that gives teenagers some authority, particularly if it's an emergency. There's rules about how the doctors are, what level of inquisition the doctors have to do, but there's some case statute out there that gives teenagers some ability to do things without talking to their parents. Well, how does that play into this new House Bill 112? How do those things interplay? So we've got case law that doesn't seem to be particularly consistent with what's going on with House Bill 112. You've got this other statutory law that I'm curious whether they're aware of that's on the books, and it's been on the books forever. I worked on the crisis line in the 80s. That statute's been on the books forever. And then another thing that crossed my mind is this kind of the slippery slope question is, if this law ends up passing, it's limited to COVID, but what else? What happens to other issues that somebody might want to come in later and argue should also have similar there's no tiebreaker here. It's very unilateral. If one parent says no, that's the end of it. What role does court play? And then the last kind of initial thought I had before I would turn it over to others to kind of chime in is, from a parenting coordinator perspective, one of the biggest challenges is when there's what I call a problem with leverage/incentive. And some of you know what I'm talking about. There are cases where people get sent to me, and for a variety of reasons, elect to pursue other methods of solving their problems, namely the court. And they tend to fall into different categories. Some of them are just jerks and have enough money to be jerks and are happy to go to court and take their chances because it's an opportunity to get revenge. So there you got those guys, girls over there, people. Then you have some people who I believe do fall into the genuinely strongly held opinion, belief category and have enough money to go to court and fuss it out. Somebody who really genuinely believes in their heart that they are doing what it's in their child's best interest. So that's kind of like a second category I see a lot. The third category I see is people who win when they go to court and don't they don't mind going to court because the judge always rules in their favor. So how do you create incentive for compromise with these different categories of people? If they don't care because they got plenty of money, or they just believe this is my such strongly held opinion, I have to go to court, or just judge always rules in my favor. Why on earth would I compromise with this person when the judge always rules in my favor? Well, I have a hard time getting those people to compromise, because why should they? And this kind of ties into that piece in the sense that I don't know that I would be able to make very much progress with getting people to even have a conversation about some of these very difficult topics if they just know that they're going to get their way. So I was thinking about it in the context of the House Bill 112, but in a much broader context, because this is an issue. And I do have people from time to time just say to me flat out, well, of course I'm not going to compromise. The judge always rules in my favor. Why on earth would I, obviously they must have the money to do it, because for a lot of people, money does come into play. Frequently with these people, their child's well-being is not part of the equation because they've got some other things on their agenda, obviously. So those are my initial thoughts of things that occurred to me wearing my attorney hat and then wearing my PC hat and looking at all the very muddied complications this potentially will create. I have a feeling, though I do not know for sure, that there was not a lot of introspection necessarily and how this law would interact with the many things that we as family law attorneys are aware are issues. We know how complex family law is. And, so those are my initial thoughts.
Sheila, can I ask you a couple of questions?
Yes.
How big is this problem of parents not agreeing on COVID-19 vaccination for the children in your PC practice? Are we making too big a deal out of something that's not that big?
No, you're not making a big deal out of it. I would say on average, 1 out of every 4 or 5 families I'm working with is having this, we'll call it conversation for lack of a better word, but that's probably not the best word because there's not a lot of conversation going on. I was talking to a family recently, and I used the expression, you can't be just a little bit pregnant. You're either pregnant or you're not. And I think a vaccine falls into that category where I give this example of you go to a nice restaurant, which I'm hoping I get to do tonight. And say you go to a new restaurant and you're really excited because you heard about a particular item on the menu, and you're like, you're all set. And they come to take your order and they're like, yeah, we're out of that. And you're like, what? And they're like, well, just get something else. And I'm like, I don't want anything else. I want what I wanted. But you just order something else because it's not a big deal. You'll come back another time. You can order something else off the menu. And I give that example to my families when we talk about things like relocation, vaccinations, things that really are not, it's very hard for people to compromise because it goes to their values usually, but how can you do both? How can you do both? And so I very much appreciate the issues, but I would say it is coming up frequently would be what I would say. And I've had a wide variety of conversations with parents about how do we navigate that. Again, going back to the restaurant example, most things we can try one thing. If that doesn't work, we can try something else. Or maybe there's some other middle ground. But on things like this, is there a middle ground? Yeah.
In the context of an issue like this, there's no middle ground. Once you employ PC, how often are you seeing an agreement one way or another? Does anybody turn around?
I have. I had one family where one of the parents said, can we agree that we'll wait a couple of months after it was a child, I think probably in the 11 to 17 age group, or I don't remember exactly what the age breakdowns are. They just agreed that they were going to wait a set number of months after all kids in the particular age group were able to start getting that vaccination and wait to see what some of the feedback was. That was a compromise because initially one of the parents was really against it and the other parent was really for it. So that was a compromise. That was kind of a time frame compromise. That's one thing that works sometimes is a time frame compromise. Encouraging them to talk to the doctors. Some of them have agreed to follow the doctor's advice. That's another way to get past that impasse. Is some of them have agreed that if the doctor who they trust and they've been seeing for many years recommends it, they will agree to follow that doctor's recommendation. That's another off ramp. That's an opportunity. So there have been some where people have found ways around it, but I appreciate that it goes to some really important and very serious questions and worries that people have. Most of the people I talk to are just genuinely worried about their children and want them to be okay. But I would say it's coming up fairly often. I started seeing it as soon as they started talking about vaccinating children, whenever that was. And I bet I've had 10 different families I've had to have the conversation with. Of course, you only have that conversation when they're not on the same page. There are some families where they're kind of on the same page, but maybe they need to negotiate the nuances of how it will unfold. But there's a lot where it's an issue. It's a big issue.
And have you seen this kind of dichotomy in any other medical area of decision making for the children to this level?
Yeah, well, vaccines in general would be, you expand it beyond just COVID. Yeah, I would say so. Treatment for other things. I think medical is a big one only because it's a little bit. Well, first of all, a lot of it's not within our own knowledge, right? I mean, most of us don't have a medical background. So it starts getting into things where some of that knowledge is way beyond the scope of any of our understanding. And so we're having to rely much more on other people. The internet can be our friend or not our friend. Some people go down rabbit holes. Some people are good at looking at reputable websites. That's a big issue, is, just where they're getting their information. So those can present challenges as well.
And I would like to encourage anybody else who has a thought or a question to just kind of chime in and put the little hand up, and I'll be looking at the screen to figure out if anybody wants to ask something or say something. But I would like to ask Judge Stein kind of the same question. How big of an issue is this? How often are you seeing this across your desk?
Well, as far as my division, the 6th division, I've had, I think, maybe 3 cases, and we haven't had a whole lot of thunder and lightning. They were well argued, but my decision, and I think I decided for the vaccination in each of the cases, and it was taken fairly well, or at least that I knew. May I speak on this House Bill 112? And Sheila, I'm so happy that I'm sorry I missed the beginning of your speech, but what I caught, you mentioned some things that are exactly correct, but just made me kind of laugh to myself, because we're talking about 100 people in Frankfurt right now on the House side. And yesterday afternoon, when I did a little research on House Bill 112 and its 3 sponsors. First of all, let's talk about House Bill 112. It is so poorly drafted. There are so many constitutional problems with it. And let me tell you what happens when someone who has a high school diploma is elected to be a representative or a senator and goes to Frankfurt. The Legislative Research Commission has a whole bunch of lawyers who work in the various committees to draft legislation such as this. Whenever you hear a legislator say, I wrote this bill, they're probably lying to you, because the LRC staff are the ones, and we might have some LRC staff people here. Anybody here worked on the LRC? We've had a number of people, but it's usually the LRC staff. And if we were to ask the 3 sponsors of this piece of legislation, if we were to go down, let's say just in paragraph 2 and saying notwithstanding KRS 158, 214, et cetera, and ask them what that referred to, they would be clueless. They would have no idea, because this is something that has been given to them by the draftsperson to do what they want to do. And obviously what they want to do here, and I'm surprised they didn't criminalize it, but they want to impose sanctions on anyone who coerces or requires a child to be vaccinated against COVID or any of its mutated strains. Now, the American Legislative Exchange Commission, or ALEC, sometimes sends out model legislation. And clearly the COVID vaccination and masks, it's been on everyone's mind for the past 18 months or so. And they even have strikes on bridges connecting Canada and the United States about this issue. How in the world we've gotten here, I don't know. And it's heartbreaking. But line 1 in this bill, as used in this section, the term child means a person under 18 years of age. Well, the problem with that is Kentucky has already named a person as a fertilized egg. So this reaches back to a woman who is pregnant, whether or not she would be able to get the vaccine if the father of the child determined that she should not get it because it would transmit to the child. Now, see, just on the first line of this bill, there's that huge problem because these folks don't know and don't care what they're talking about. Sheila, you mentioned the Constitution, that things must comport with constitutional restrictions. I bet you $10, more than that 60% of the members of the House have not fully read the Constitution. Not only have they not really studied it, they have not really read it. And certainly if they read it in high school, they haven't reread it once they were elected. And I tell you, one of the biggest shocks that I had in my time in Frankfurt was when I held up the Kentucky Constitution and began to talk about it. And I bet 70% of the newly elected folks over there don't know that Kentucky has a constitution. Because when I held it up several years ago, they began to look around and say, what is this? What do you have? You can see how disheartened I am. I have good news though. This bill, along with so many others that have been pre-filed and filed by a group of freshmen and semi-freshman legislators on these rabid social issues, have gone to the committee, have been sent to the Committee on Committees, and will likely rest safely there until the adjourning of the session. There are a number of pieces of legislation. The LRC website is great because it gives you can see where the representative is from, what their organizations are, what their education is. And I started to email Representative Baker last night and ask him to join us today. I believe Ms. Combs had already asked him and he was unable to. It would have been nice to have been able to ask the sponsor of this bill exactly what his intent was. But I've got to tell you that the last thing this guy wants is to be in a Zoom meeting with a majority of women lawyers and judges. That would be the very last thing on his mind. So the good news is this is an issue that could still be brought in to legislation by way of amendment in the last hectic few days of the General Assembly. That's what a lot of bad things happen then that members who are looking for things simply are not able to catch. And because facial cover, masks and COVID vaccinations are such hot button topics right now, I would not be surprised if somebody on a conference committee or a free conference committee, which means you can do anything to a piece of legislation, might try to sneak it in. We might end up with something similar to this, but I do not believe that leadership in either the House or the Senate would allow such a blatant separation of powers issue as this bill get through. That makes sense. Mhm. Any questions for me?
Yeah, I just have a question. So I just want to make sure I'm understanding what you're saying. You're saying don't, I'm one of the people, I don't know if I was the one, but I'm one who mentioned to Anna and Tamara that they may want to talk about this in a meeting. I was wondering at the end of this, if we all should call our legislators right away and pitch a fit about it. But I think it sounds like you're saying it's probably not going to go anywhere anyway. So it's just kind of a thing to talk.
Yes, it's a thing to talk about. And I've been able to look into this General Assembly a little bit, and there's a caucus that is emerging there. I was a proud member of the Bitch Caucus many years ago, but there is a caucus called the Liberty Caucus that is emerging. And I think Representative Baker is one of them. A young woman from Northern Kentucky, Savannah Maddox, is kind of a leader in that group. But there are a number of people who were the ones who took part in the demonstrations at the Capitol regarding COVID restrictions that Governor Beshear had imposed. I don't know that they're certainly not in a majority now, and I don't know if leadership is going to throw any bones to them or not. That's all I have to say.
This is Jean Collier, and I just wanted to have asked at the end of what you were saying. You said this is a blatant or violation of separation of powers. And
Yes, ma'am.
can you explain exactly what you mean by that to me, please?
I mean, in paragraph 3 of this bill says that if this legislation is violated, if somebody tries to order that a child be administered a vaccine, they're telling the judicial branch that there's nothing we can do about it.
In
That's
other words, the courts can't even independently review it.
right. There's nothing we can do about it.
Oh, yeah, you're right. That's not gonna go over.
Kind of blatant.
Thank you. I'm sorry.
Oh, no, a good question.
That's one of the questions I was racking my brain trying to think if there's any other example of anything, particularly when it comes to healthcare, where one parent essentially can veto, and not get any judicial review and no opportunity to get any kind of relief. It's just, well, the other parent says no, so we don't have any recourse.
It's very frightening. And in one of the cases that I had in front of me, the party in opposition had done some scholarly study and in the pleading had presented some of that. When I reviewed it, I still believe the science more on the side of vaccination to protect this particular child. But you will find that they don't talk about science in the committees that hear these bills.
Your Honor, one of the things that struck me, I mean, this just reads as unconstitutional on its face, but there's no distinction drawn between the rights of a sole versus joint custodian. So it's just one parent can put the kibosh.
What little detail? Are you kidding me? You know, when I was chair of the Judiciary Committee, and I've learned from one of the best, Gross Lindsay, the bills that come to the judiciary clearly are, well, all bills are important. These are very, very important. We cleaned those bills up. We scrubbed them before we let them out on the floor, just for things such as this, the things that it leaves out, the broad constitutional violation it is. But that's the kind of scrubbing that we did. And unfortunately, I don't think that they do that anymore, because we see, you know, in past sessions, we've seen legislation come through that's faulty when it comes to answering questions.
Yeah, there's definitely some holes in this thing. One of the things I wanted to ask you about, Your Honor, your interpretation under, I guess it's section 4D, a child who has not received a vaccination shall not be subject to, part D is limitations on participation in social activities or functions. And the example that leaped into my mind was an invitation to a birthday party. So I'm just kind of curious if you have any thoughts about broader social implications based on some of this very loose language in here.
Well, it's that overkill that the COVID situation and masking situation has come to represent, that you can do whatever, whenever you wish, that you have complete freedom without any consideration for others. I mean, this is ridiculous. You can't require face coverings for people in health facilities, in nursing homes. They have not thought through this. Oh, and paragraph C3, that dangerous record keeping related to exposure, testing, or contraction of COVID-19. Can't keep any records about it either. Yeah, I read through this bill several times, and every time you look at it, something leaps out at you.
I just was amused at my own meanderings around the unintended or perhaps intended consequences. I'm thinking, okay, we've got some guy who's an axe murderer serving 14 life terms in prison, but his rights have not
Veto.
that he gets to say his kid doesn't get vaccinated. You know, wow, my mind unfortunately goes to that kind of thing.
Yes.
Darn quickly. So.
When I was doing this thinking, like Mr. Sheila was, you know, I was trying to think about other situations of veto power. And even in face of domestic violence, that's one factor among many to be considered when the court is making best interest of the child decisions. But, you know, for this to get carved completely away, it seems extreme. Is there anything that would be helpful to come from the legislative power to help the courts inundated with this issue that you can think of?
I'm going to defer to the other two judges involved here. I see two of them, I believe. I have become so jaded about the legislature that I don't even think those thoughts anymore. Lucinda or Libby, what do you all have to say?
I'm concerned if they try and do anything, they're gonna make whatever it is worse.
Well, you know, and I'm not kidding. This paragraph 1 defining child as a person under 18 years of age, when we already have defined a person in Kentucky as a fertilized egg. Now, somebody could make an argument regarding the a pregnant spouse or a pregnant girlfriend or whatever. That could cause some real problems, friends. And this legislation would allow it.
And then the notwithstandings there on section 214, 032 is the definition of child already there. So.
Well, you know, you can't be bothered with those technicalities when you're writing legislation in Frankfurt.
Excuse me, this is a question from Jean Collier again, and I obviously know nothing. But given that that is the definition of person, how is any abortion in Kentucky ever accomplished?
That's exactly what those of us who were opposed to that definition. It has never been brought to bear yet. It could be, but I think the arguments that we put up, it was a marathon session. I recall when that happened, we were on the floor for 3 or 4 hours discussing it. You know, it affects so many things. It affects taxation. It affects everything. And so far, the proponents got what they wanted. They were able to score 1 for my pro-life credentials. But it doesn't, thank goodness, no one has pushed it to the point that it could be pushed.
Okay, thank you. Just asking. Thank you.
Well, you're once again, Ms. Collier, you're asking excellent questions. I also looked at some of the legislation that his co-sponsors have filed, and I don't know whether this is appropriate, but I'll go ahead and do it anyway. Of course, they're all members of the pro-life caucus. They are members of the guns rights caucuses. The liberty, let's see, I think Ms. Maddox is the one who proposed legislation that passed that there no longer has to be training for carrying concealed deadly weapon. You don't have to take the classes that we formerly had to take. That helped me a great deal. I got my carrying concealed and the classes were great, but now anyone can carry concealed. And the Liberty Caucus has also filed a piece of legislation for the age to legally possess a gun and purchase a gun from 21 to 18. Another big issue that bothers them, gender transition. We're not going to have any boys playing on girls' basketball teams. That's a big issue. There are several bills that these folks have filed about that. You all know what the key scholarships are. That's helps post-secondary education for students who have good grades and they're able to have tuition paid, grants paid for the tuition for public and private schools in Kentucky. One of these guys has filed a bill for the key scholarships to go to proprietary schools. You can figure out what those are.
I don't even know what that means.
Well, it means cosmetology and barbering and the kinds of schools that are kind of fly by night. You've heard of those sorts of schools.
Well, no, but anyway, I'm being educated. Let's just say I'm being
They
educated.
exist to, unfortunately, to make money for the owners and rip people off. Let's see here. Constables are constantly looking to have more law enforcement powers, and they need blue lights. Here in Lexington, we've had a small controversy about that, but the constables have their legislators who want them to have the duties of law enforcement, responsibilities of law enforcement without the training. And of course, parents' rights to refuse facial coverings for their children as well as themselves.
Does anybody know if this type of statute has been successful anywhere else in the country? Is anybody aware of success in any states?
I think forms of this have passed, but not nearly as baldly unconstitutional and foolish as this one. But the thought that both parents should be able to control the vaccination of their children around COVID issues, I'm sure has passed somewhere. It's my research. I haven't gone that far in the research. Once I completely retire, I'll have time to do that and we'll enjoy it.
There's a story that for some reason I feel compelled to tell now, though I can't imagine anybody would be really interested. I was in Frankfurt working in the Capitol building when the concealed guns bill legislation was passed.
Mhm.
And I was right there on the second floor, working for the judiciary, and Bob Stevens was the Chief Justice.
Yes.
And he came out, he was really up, and because at that, one of the things it did was it meant the third floor, which was open over the second floor, legislatures or anybody, they could carry guns.
Mhm.
But on the second floor, he did not want people carrying guns. And so when I first read about this in the paper, I thought, well, I don't have to be concerned. The Chief Justice is going to take care of it. I had confidence in the man. And later I realized even he couldn't make agreement over the separation of powers.
The NRA wielded at that time such magnificent power over the legislature. Anything that the NRA wanted, there were legislators. Bob Dameron from Nicholasville, lovingly known as Bullet Bob.
Mhm.
Anything that he proposed that the NRA wanted would pass.
Yes, I remember him because my son, who was in middle school at the time, was able to be a page because Ernie Fletcher at that time was our representative, and he was absolutely wonderful to us.
Mhm.
And I remember I said, Nate, at that time, I said, well, how do you feel about this bill? Would you like to see it passed? He had taken a Coke to Representative Dameron. He said, no, I don't want it passed. Kids will bring guns to school. I know kids.
Oh, a premonition.
Yep, sure it was, wasn't it? My son is a very smart man.
Well, now I've only been to Frankfurt once since I left the Senate. It's changed a great deal. The security, you can't take an umbrella in because of the sharp point, but you can take your firearms in.
Mhm.
Well, if it looks like this law is not going to pass, and then we kind of back up to where we are, the reality is that the cases that have been passing recently do give good guidance to attorneys and give decent guidance to parenting coordinators and give really good guidance to parents. I mean, you now have something where you could kind of hold it up and say, well, this is what this says, take it for what it's worth. But I see it as helpful in terms of when I've got people who are really intransigent on an issue, is to say, well, I've been telling you forever that if you can't work it out, this is what's going to happen. The judge will make the decision. Well, here's your proof. I'm not just saying that.
That's right.
If you can't work it out, how do you feel about, and this is what you can say to your clients, is how do you feel about the judge, I call it the complete stranger at the courthouse, on
Yes.
purpose, try to create that distance. How do you feel about that? Most of them really don't like that idea,
Mhm.
but then it competes with that desire to have the outcome they want. But so I have found those cases to be enormously helpful. I'm glad they're around. They give some framework, whether it's Troxel v. Granville or the Young case or the,
Oh, yeah.
I think they are really, I'm almost surprised there hasn't been a case like that, and that it took until this year to get one that really talks about things that explicitly. But nevertheless, I think it's an incredibly useful tool. And one other thing I'll say is, I think it was Tamara was asking me how often I'm running into this issue. Pretty often. But I also have to remember that I get sent some of the most challenging
Some of the
cases,
challenging ones. Mhm.
and it's not all of them. Many, 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 many people around the world and here in Lexington, even my most difficult of PC people, are figuring this out. But there's a pretty loud, substantial minority who are getting really stuck. And I get it. I mean, it's hard. I thank God I'm done dealing with that kind of stuff and don't have to, deal with those kinds of issues, because I recognize how difficult the topics are. And, people who love their kids, the ones who are doing it out of genuine care for their children, it's hard. This is really hard. So.
Well, I'm so glad that this exercise is taking place. I applaud and thank the leaders, the co-chairs of the family law section, because see what an education this brings with things that, 30 years ago, I had no idea what went on in Frankfurt, but after 17 years there, I have a pretty good idea of how these things work. And otherwise, people assume that everyone there is armed with the knowledge they need to decide public policy accordingly that meets with the Constitution. But that's not the case, unfortunately. And sometimes these things get through. And another issue that affects children, certainly, although we don't look at it that much, is critical race theory. I can't tell you how many pieces of legislation have been filed by leadership, which means it's going to pass, that will prohibit teachers from 11th grade history teachers, which is what I taught in high school, from talking about slavery.
Gosh, good heavens.
If you'll look at some of those pieces of legislation, it made me nauseous when I read some of that, and some of that is going to pass. I don't know the final form, but it will pass.
Lord have mercy.
If any of you all read the Herald Leader, there's an excellent editorial piece today from, I think her name is Liz Prather. She's a teacher at Lafayette High School in the English department, I think, who has written just an excellent, excellent piece about what that sort of legislation does to teachers and then to children.
I just wanted to, I have to jump off. I have a hearing coming up here, but thank you all for talking about this, especially we kind of got off on some tangents, but it is an important question. I've only had a couple cases where we are struggling with parents disagreeing about vaccinations. I've done, in those cases have all settled, thankfully, but I've always said, look, I've got to get I can't just make it up. I can't just decide on my own. If you really want me to look at this, we're going to have to get some experts in here. We're going to have to really try and figure this out for me to decide. And that sometimes is enough of a barrier. They don't really want to do that. They'll figure it out because they don't want to spend the money on hiring a bunch of experts and paying for it. But it is, as you said, it's a compelling issue. Parents, some parents are just wacky, but most parents, I think, really care about what is going to happen with their kids. And, I feel privileged that they might want me to make a decision, but it's a frightening place for me to be too, because I don't know. So Thanks for working hard on this. And what I would like to ask before I go is to ask Judge Stein, if you see that this thing has legs,
Oh, I'll
please
sound
let
out the
everybody
alarm.
know, because I think then people need to call Frankfurt and say, look, this has got to be seriously redrafted, or else there's going to be serious.
Yes, because we do have, although there's a supermajority of Republicans, which is fine with me. I was in a majority of Democrats, never a supermajority, but those guys, for the most part, understand what is outrageous and what isn't
Okay.
most of the time.
But you'll let us know if it's
I'll
not
let you
headed
know.
in. Okay. I've got to leave. Good to see everybody. Thank you.
Thank you, Judge. We're getting to the end of our session. If anybody else has any final questions or thoughts to share.
I missed a lot, and I'm sorry, I jumped out for a case management, but I would just echo what Lucinda said. I think the guidance that we're getting from Court of, we have our little listservs, all the judges statewide, kind of the guidance we're getting from Court of Appeals and Supreme Court is that when these issues come up, it's a best interest, unless this law goes through, which would be a separation of powers nightmare, I believe, because it's takes away our ability to be judges. But when these come up, the kind of the guidance we're getting is we had to make some sort of factual determination. We can't, judicial notice that I believe vaccines are good and therefore kids should get them isn't going to get it done. That's not a best interest. So, but best interest can be any number of things. I don't necessarily have to have a CDC expert testify. I've got one right now where the argument is the child's going to miss a whole lot of school because the regulations for vaccinated kids versus unvaccinated kids and exposure is totally different. And so COVID aside, this kid is going to miss twice as much school as she would if she was vaccinated. So those I could hear from a teacher then about what is the school policy. So we just have to have an actual factual determination regarding best interest. We can't just say, I like vaccines. Vaccines are good. I choose parent who wants vaccines. So,
Right.
And the pleadings that I've had so far have allowed me to do that because the pleadings were good. I hope I haven't offended anybody because I do tend to get on a soapbox. I've tried to rein it in these 8 years.
Jean Collier says the same thing.
Please never do. And also I just wanted to make sure everyone is clear to give Ms. Donovan some extra street cred. She was the PC
Yes.
on Birch v. Lipscomb.
Yes.
So she has delved into this issue whole force.
Sheila, thank you so much. You are a real asset to our
Thank-
bar, and we appreciate the new service that you're
Yep.
providing.
And she
Effective-
has made herself available on her birthday to be here with us today. So
Wow.
double thank you, Sheila, for
I was
listening.
also,
Well, it's good to see Susan Kennedy smiling there, isn't it? Back. So good to see you, Susan.
Well, thank you, everyone. This will conclude our, Susan, did you want to say something? I didn't mean to cut you off.
mute
She's
still,
muted.
you're muted.
Yeah.
Okay.
We'll see you in court.
Thank you, everyone.
All right,
again.
you all. Thank you.
So much, Judge Stein. Thank you, Sheila Donovan, and I'll be seeing you all soon. Have a good afternoon, everyone.
Yes.
Thanks, guys. Bye.
Bye.
Thank you, everyone. We'll get the CLE info
And
out
thanks,
ASAP.
thanks to Dana too for
Thank you.
setting it up. Thanks.
Yeah.